Good evening, everyone. Chip Cooper for FTC Guardian and my partner, Alan Cutts. We're here for the first hangout in the month of March. I was going to say May. It's not that we're not that far down the road yet. I don't know. I was thinking about springtime because it feels like springtime is here. We're now in the first hangout, the first half of March, 2019, and we've been having spring-like weather here. Feels a little bit like May. I guess that's why I got confused there for a second. But we've had some great weather. I've been out paddling on my paddle board in the ocean last weekend, had a great time. And we're sort of, settling back into our routines after this traffic and conversions event we went to. And, about a month prior to that, we were off at the Marketers Cruise. So now we're sort of settling back into our routines, thank goodness. We like that. Alan, what have you been up to?
Just trying to get back into a routine from TNC. It's been 2 weeks now, but just a lot of follow up and just trying to get back into routine. I'm a routine person, so I need that.
I think we're both routine persons, actually.
Yeah. So I need to get into that routine and get going. So this is kind of like the first week to really get back into it and get back on my to-do list. So it's good. Everybody, I put a little chat up there in the box that says if you have questions or whatever, please check make sure you tick the little box beside the question area down below where you have the questions. Let me see if I can find what it looks like down there. I'm going to go to the chat box. You go to chat. Yeah. Down at the bottom is where you hit the chat. If it's a question, mark it as a question versus a regular chat when we get going. So we can actually see it and get it answered. All right, Chip, I'm ready.
All right. So let's get moving here. I'm going to go to share my screen, and that should be it. So tell me that if you can see that screen there, Alan.
Yes.
All right. You see the title there. We're talking about new FTC cases that continue to hold digital agencies liable for deceptive ad claims. And if you're an agency or not an agency, you might be sort of operating under a misconception we're going to talk about in a minute, that agencies are not regulated by the Federal Trade Commission. Not true, they are. And there have been several cases in the last 3 to 4 years, and we're going to talk about the more recent of these cases in this particular hangout. So if you are a digital agency, you're in the right place. Or if you're sort of thinking about being one, you're in the right place. Or if for some reason you're just interested in knowing what the rules are relating to agencies, you're also in the right place. And you've seen this housekeeping announcement a number of times, so I'm not going to go through it there. One thing I'd like to announce here is that we have a new book here dedicated to digital agencies, and you can see the title there. Are you a trusted advisor? Discover how your digital agency can attract and retain better high-paying clients, become their trusted advisor. And at the end of this hangout, I'm going to give you a link so that you can actually purchase it. It's very, very inexpensive, and you may be very interested in it. And getting back to this huge misconception, which is that agencies are not regulated directly by the Federal Trade Commission. And you can see that the not is deleted there because that misconception is not true. There are literally 50 plus years of legal precedent holding agencies liable for their own actions. We'll talk about that more in just a minute. But before we do, it's really important that you understand legally what an agency is, because you have to be an agency under the rules of the FTC before you're even regulated. So step one is, are you an agency? And then if so, what are the rules that apply? So you see there in pink the first 3 elements of an advertiser, right? Number one, you create ad copy. You write messaging. You write hooks for funnels. You write sales pages on your website. You do promotional posts on social media. You write messages that are approaching a customer and asking for a call to action, right? Or presenting a call to action, asking for action. So number one, you're writing ad copy or messaging. Number two, you're placing ads directly or indirectly that target U.S. customers. And if that is all you're doing, you're marketing your own stuff. Or if you're an affiliate, you're still an advertiser, even though you're marketing your principals' material, their products or their services. So as long as you stay within those first three elements, writing copy, placing ads that target U.S. customers, then you're an advertiser, and we know that advertisers are regulated. But then by the FTC, of course, but then when you add the fourth element for one or more clients, then you become an agency. So when you add the first three to the fourth for just one or more clients, then you're now regulated as an agency. And you see the bottom there in yellow, there are significant legal consequences. So here are the rules now. If you qualify as an agency with those four elements, these are the two basic rules in order to be held liable for a deceptive ad claim as an agency, not as an advertiser. Number one, did you actively participate in the ad claim, in the messaging, right? Did you either write it or participate in the development of it or writing of it? Number one. And number two, did you know or should you have known that the ad claim was either false or deceptive? And deceptive can mean partially true and partially not true, right? So if these two elements are satisfied, then you as an agency are potentially liable for a deceptive ad claim by the Federal Trade Commission. So two very important things. Are you an agency? If yes, then if these two elements are satisfied, you can be held liable. And as indicated at the very beginning of the presentation, it's not new. There's over 50 years of legal precedent holding ad agencies liable. All right, now before we get to the two cases that we're going to be talking about in this presentation, there are three prior cases. You see the names of them here involving the agency Deutsch LA, Synergix, and Machinima. All three of these are discussed in the Trusted Advisor book, which we're going to give you a link for at the end of this presentation. The first one up there, Deutsch LA, was covered in a Hangout back in 2017. And if you go to the members area and search agency, you'll see a link to the replay video for Deutsch LA. All right, now we're moving into 2018 after these first three cases, which came before, and we're talking about a case involving Marketing Architects. Their client was a company named Direct Alternative, as you see at the bottom of the slide, and they were selling weight loss supplements. And here is something that is just a really bad advice for anybody that is acting as an agency when they're confronted by the Federal Trade Commission to say something stupid like, we're not the advertiser, which is exactly what one of the principals for Marketing Architects said, right? We're not the advertiser, meaning we're not liable. Our client is the advertiser and the client should be liable. Well, of course, the client is the advertiser and could be held liable, of course, for a deceptive claim. But as we've just seen, the agency can also be held liable under the two rules that we've just talked about. So if you're actually ignorant or stupid and actually claim that you're exempt from regulation to the FTC, they really don't like that at all. And you can see here an FTC blog post that sort of made fun of this particular agency, Marketing Architects. And here's the FTC blog post, quote, "Relying on a but we're not an advertiser defense is a dubious strategy, giving the potential breadth of liability under federal and state consumer protection laws. The ostrich approach is unwise." But this statement and this blog post illustrates the misconception that we talked about just a few minutes ago, which, you know, based on people we talk with when we go to events such as T&C, Traffic and Conversions, there are a lot of agencies who really don't understand that they are regulated as an agency. So this is truly a misconception. All right, now the takeaways in this particular case involving marketing architects. The FTC made claims for false and unsubstantiated claims, fictitious testimonials, meaning they were fake, they didn't exist, and deceptive formats or native ads, where the ad didn't look like an ad. It was a disguised ad known as a native ad. And if you're not sure about exactly what that means, if you do a search in our members area for native ads, you'll probably see 3 or 4 replay videos for Hangouts. They also violated the gut check weight loss claims. And there's going to be sometime later this year a Hangout devoted to what in the world are these so-called gut check weight loss claims. Essentially, the FTC commissioned a study a while back and came up with, I believe it's 7 claims that cannot be substantiated as true because science doesn't support them. They're impossible. One of them, I think, is lose weight without diet or exercise. Cannot happen, right? So this particular agency, on behalf of its client, violated one or more of these gut check claims. There was a permanent injunction, asset transfers, 10-year annual compliance and record-keeping reporting, and a $2 million civil penalty, which is a fancy term for a fine, right? So that was the unfortunate result in that particular case. The next case, also a 2018 case, involved an agency known as Creaxion. They were representing a client called Fit Organic, and you'll see in a minute an example of a social media post that was insect repellent, right? An insect repellent product. And what happened was that that before the most recent Summer Olympics, I believe somewhere in maybe in Brazil, there were a lot of concern about mosquito bites and potential diseases being spread. Particularly the Zika virus was one that people were concerned about. So the business opportunity was to have competitors here to actually plug this mosquito repellent. And this woman here was one of the competitors in the Olympics. The problem is, or was, that these athletes, including the young lady here that you just see, made these commercial posts on social media, Pinterest. A lot of them were on that particular platform without any disclosure that they were being paid to pitch these products, right? Also, Creaxion partnered with a publication called Inside Publications, and that was a publication that devoted to gymnastics and sports related to the Summer Olympics. And so Inside Publications also published these endorsements for the product, the mosquito repellent product. And so that was a problem. Also, you can see there they were paid for these posts and these endorsements, and these ads were also deceptively formatted because there was no indication that it was an ad and no disclosure that it was an ad. And the result was a permanent injunction, a 10-year annual compliance and record keeping, and there was personal liability for the principals of the agency and the magazine that were jointly promoting the product, and a mandated self-enforcement compliance program, which is something we'll talk about in a minute, which is really what our certification program for agencies is all about. So here it is. I think you've heard us speak of this a couple of times in prior Hangouts. We have a new certification program for digital agencies known as the Certified Digital Compliance Professional, CDCP, very new. And it is designed to comply with FTC requirements for a compliance program for agencies. And it is also, we believe, a necessary ingredient to provide the foundation for agencies to act as a trusted advisor. And that ties in with this new book that we're going to be talking about right here. And here it is. This is another shot of it. And if we go here, we'll see just a little bit about the basic idea, the concept of the book, and that is trusted advisors build trust relationships with their clients. They're not just acting as a hired gun merely looking at an increase or an uplift in conversions, let's say, but they're also seeking to become a trusted advisor to their client so that they can advise across the board with respect to a number of the advertising opportunities and to build this strong trust relationship. That's what the book is all about. The cost of the book is $7.97, includes shipping and that sort of thing. And here is the way to get it, ftcguardian.com/book. That's the way to do it. And you see this particular diagram is in the book, and we're talking about that trust relationship. And this is sort of tongue in cheek. The obvious ultimate trusted advisor, I was trying to think of what in the world could I present that would be an image that all of us, or most of us anyway, would recognize as the ultimate trusted advisor. And of course, it's Yoda, the Jedi Master. Obviously, I don't believe that our certified digital marketers here are going to rise to that level. But anyway, that's what you would shoot for. The takeaways in this Hangout are that there are 2 new FTC cases that continue to hold digital agencies liable for deceptive ads. And the rule is, if you're an agency, then there are the 2 prongs that you both participated in the ad and that secondly, you knew or should have known of the deception. And if you're an agency or if you're considering starting up an agency because you're experienced, let's say, in internet marketing, you should consider our certification course to become a CDCP, a Certified Digital Compliance Professional. And you need to consider purchasing our book that talks about how to get better, higher paying clients by becoming their trusted advisor. And here is the link again, $7.97. It is, and if you purchase the book, you'll get an immediate digital download of the PDF so that you'll have it immediately while the book is being shipped to you. The link again is ftcguardian.com book. The tags are going to be agency, digital agency, trusted advisor, and certification. So that is the end of this brief presentation. And let me get out of the share my screen. And we're now available for questions, both Alan and me.
Yeah, the first question I see is about the book being Kindle version. No, we developed the book. I mean, this is really only for digital agencies. It's one of those free plus shipping offers. It's what we're using as a lead in for digital agencies, and just a really good book about being a trusted advisor and stuff. So, and to get more people into our funnel for our digital agency program.
Right, and the 2 cases we talked about in this presentation are discussed, obviously, and the 3 that were indicated as prior cases are also talked about, plus a lot of material about being a trusted advisor and also other material about the Federal Trade Commission, that sort of thing. So we think that if you are an agency or thinking about maybe becoming one, it would be a good purchase for you and a good resource for you.
Yeah, I'm looking up. Hang on. Somebody asked about the agency program. Let me see if I can find a link. Current members. That's what I'm looking for. Because obviously we have 2 different prices. One's for current members and the other's for folks that are not members of. Here's this is the link for the certification for current members, and then the link for the book is HTTPS. I'll put that in there too. ftcguardian.com/. If you're not an agency or the book really isn't for you. It's for people who want to be agencies. That's what it's for. It's for people who want to be agencies or are already agencies, and they want to add this to their to what they're doing, so they can make sure they stay out of trouble and they become a trusted advisor for it. So anybody else? It says becoming a trusted advisor sounds like a good idea, but does that give you any additional protection against liability? You know, you want to speak to that a little bit because there is a little bit of a yes to that.
One of the things that's really worthwhile in the book
it's in the book too, right?
Yeah, the book talks about these cases, but one of the 5 cases, the 2 that we talked about in this presentation and the 3 previous ones, total of 5, one of those 5 presents a very unusual benefit of being certified. And the benefit is if you have a compliance program in your agency, and the book helps you, develop that program. That's the purpose of the book, right? So the case basically says that if you have this compliance program in your agency, and then if something falls through the cracks, and in the particular case we're talking about, the agency was Starcom working for Microsoft, and downline from Starcom were some YouTube video people who were playing games on the Microsoft Game Player product that was being launched, and they did so, and they were being paid to do these games and the videos with them, but they didn't disclose that they were being compensated. Right? They were endorsers, but didn't disclose the material connection with the advertiser, which was Microsoft. So it was an FTC violation. But a senior official from the Federal Trade Commission wrote what is called a cover letter on FTC stationery, a district director, to both the agency Starcom and to Microsoft, the advertiser for the Game Player product, saying that you are responsible legally for this downline mistake that these influencers made with the YouTube videos. However, we've investigated you, and we see that you had this compliance program where you trained employees, and you had a program that was living the idea that we're trying to get everybody to live and walk the walk, which is compliance. So therefore, we're thinking that even though you're responsible, we'll give you a pass. So we're thinking, Alan and I are thinking, wow, this is like, it's not an insurance policy, but it's sort of like a virtual one. The FTC is signaling through one of its highest officers that if you play ball, if you actually walk the walk in terms of compliance, have a program, then you're likely, not guaranteed, but likely to get a pass if there's some, issue that falls through the crack.
Yeah, some misgivings. Okay.
So that's really the foundation of this certification program, that particular case involving involving Starcom and Microsoft. So that's the foundation of it, because there's a real benefit to do it, right? A tangible benefit. The other benefit, of course, though, is once you understand and have a working knowledge of the rules of the advertising game, which is what the agencies are playing in, right? Then you're more equipped to advise clients, not as an attorney, right? But to say, we understand generally what the rules are here, and we think that this is a higher risk for you, but we can put you in an advertisement that goes along this track, some of the stuff we talk about in our Hangouts, and we can get the same conversions with less risk. What do you think? Well, what do you think the client's going to say? I like that. That's pretty good. You're thinking about me and my brand. You're trying to get me the results, but you're also doing it in a way that acknowledges that you appreciate the quality of my brand and my business, and you're trying to, steer me in a path where I get, probably a safer approach to it and the same conversions with some of the same strategies we've talked about. So really, it's the trusted advisor, which the knowledge of the general rules will help you be. And it's also this so-called virtual insurance policy offered by the Federal Trade Commission. That's why we have this darn certification. And we're sort of like the evangelists going around at traffic and conversions trying to convince people that this is a good idea. So, it's a challenge for us, because a lot of people, a lot of the small agencies, when we say, do you realize that your 50 years of legal precedent can hold you liable as an agency? No, really? Yeah, really. And so we're starting from a position of this misconception. And now right now, by virtue of attending this particular Hangout, more than probably half of the small digital agencies out there about their liability exposure. So that's what it's all about.
There's something here from Anthony, but I don't quite understand. It says, how about FTC compliance around product producers and their ad agencies? Is that a separate topic to come up?
Producers. I mean, the producer is the manufacturer of a product, right? Yeah. I mean, in the case we're just talking about, it would be Microsoft manufactures this game player station, right? So obviously, you know, they are an advertiser. They own the product that is being promoted. They're the advertiser. And, you know, they have legal obligations of an advertiser. They have to substantiate ad claims, all sorts of other rules, right? And if they violate those rules, they can be liable. The point we're making here in this particular presentation is the agency who worked with them and created the message, or at least participated in it, you know, can also be liable as an agency. Yeah. So that's the way it is. And, you know, I remember, I think it was about a year and a half ago, I watched part, not all, I mean, maybe 2 or 3 years worth of the series Mad Men. I think it was on Netflix. And it was, you know, but this series is like 6 or 7 years old. I just didn't watch it when everybody else was watching it, right? I just started watching it last year because I was interested in agencies. And in one of the first episodes, Don Draper, who's the head strategist for the agency, is meeting with top brass for one of the major tobacco companies. And this is back in the 60s when everybody smoked, right? And so the ad agency execs go into the conference room. Draper's there with a couple of his subordinates. They're meeting face to face across and the ad agencies are saying, you know, we don't like these damn rules by the Federal Trade Commission. And Don Draper says, you know that we're not allowed to use the word health in a cigarette ad anymore. And this is what the FTC had said back in the 60s, right? So Don Draper for the agency is not acting as an attorney, just saying, you know, we know that we can't do this anymore. We can't use the word health in the ad. And the exec for the cigarette company said, yeah, we know it, but that's why we hire you guys to figure out how to get around that, right? So, but the idea was that Don Draper was advising his client as to what they couldn't do legally. You know, you realize we can't do that. And that's the kind of advice that you need to be able to give a client that you're working with as an agency. That's a good example of it. Any other questions? I think Alan has muted himself.
I was doing a test order for somebody because somebody said they got an error. So Michelle, I grabbed your email address here. I just tested it myself. That's what I was doing in the background, doing a test order, and it worked for me. So let me, if you do a screenshot and email me at support and just tell whoever answers it's for me, do a screenshot of the error that you're getting. Because I said when I saw yours, I just went in myself and did a test order. The other one I saw here from Norm. Norm, I don't even have a copy of the book myself. I had 60, 70 copies we gave out at TNC, and I don't have a single copy left. You know, we can do coffee if you want to, but I don't even have one to give you. I don't have a copy of the book myself. And then Sue posts something which I don't understand. Okay, it's saying invalid. Oh, invalid credit card. I'm getting invalid credit card. I don't know. I'm putting in the correct information. Huh. Okay, I'll have to try it, and I'll let everybody know. I'll send out an email, but I'll give it a try because it just went through for me just now. Somebody had a question here.
Alan, you just bought the book.
Yeah. I had you to do a test order, so I had to do it. Something from Sue, and I don't understand. He says, and I don't understand the question. Is I know Inside Magazine as that's my field. So are they involved in the non-compliance suit, and are they equal to the company with the ad? I have no idea.
Well, the magazine is a publisher of this magazine, and they published they were not merely the publisher. If they had been merely a publisher, they probably wouldn't have been involved in an FTC claim. They were actually a joint venture partner with the agency, right? So that additional element, the fact that they actually had partnered with the agency, I think brought them into it. If they were just a totally independent publisher of a magazine, I don't believe that they would have been held liable. It was the fact that they joint ventured and knew about the plan and helped conceive of it, which meant that they were more than merely a publisher. They were a joint venture closely tied in with the agency itself. I think that was the issue there.
Yep. Yep. Phil said something about the webinar tomorrow. Phil, the webinar tomorrow is strictly for, we're doing it for Ken Krell. It's our basic webinar, a presentation to bring on new members. So there's no need for, if you're already a member, there's no need to go to it. It's our regular one that we do for new members. And Ken Krell, we met Ken Krell at TNC. He wanted us to do one for him. So we're doing it for him. And we decided we invite people on our list that were still basically on our prospect list. So your name must have been on the prospect list somehow. You must have used a different email address or something. Where is the line between giving legal advice and personal advice? I'm not supposed to give legal advice.
Well, I don't know that. I mean, if you're an agency and you're in this same situation I just mentioned with Don Draper on one side of the table and his clients on the other, I think it's very obvious that Don Draper is not giving legal advice. He's just saying, that we can't use the word health in a cigarette ad anymore, because he's been advised by his agency law firm of that. And of course, these ad execs for the advertiser, the tobacco company, they knew it too. In fact, it had been publicized. So I think, generally speaking, the circumstances will make it very clear that you're not acting as an attorney. You're an agency, right? But you're saying our understanding of the rule is that, so-and-so, you need to put a disclosure on this social media post for the insect repellent, and it needs to say #ad. That's what the FTC says is required now. And I think if you're acting as an agency, you don't have to say, now, we're not giving legal advice. I think the idea of not giving legal advice is probably very appropriate in your agency contract with your client, right? We don't give legal advice. We may provide suggestions, but it's up to you to check with your attorney, Mr. Client, to verify that, what we're suggesting regarding legal requirements is valid, that sort of thing. You're responsible. We're just giving you our general understanding of the rules of this game. So I think if you cover it in your contract with the client, and then you're meeting with them and saying, hey, we've got to do this disclosure, there's not going to be any issue.
Yep. Okay. Yeah, I see several people posting questions about the credit card. I'll have it checked tomorrow. There might be something. I guess there is something wrong on our side. Maybe it just went through for me since mine was cashed already because I had already tested it.
Certainly are encouraged by your interest in
Norm. Send the email to support@FTC Guardian and just tell whoever that it's to pass it on to me, and they'll send it over to me. I think Chip said that the magazine didn't have a JV relationship. What if we have a website publisher? Let me see. It think Chip said that if the magazine didn't have a JV relationship, they may be off the hook. What if they have a website publisher and have an advertiser on the site? I thought we were responsible for the ads. I don't understand.
I'm not sure I understand the question. Yeah. Let's talk about an old-fashioned publisher, a newspaper. They sell ads in newspapers. They still do a little bit, mostly for their website, which is affiliated with the newspaper, right? So the newspaper is not required to validate. I mean, the ad, it's not required to investigate whether the ad is substantiated. If their customer wants to buy a certain space and publish it, they do it. They, the publisher gets paid and prints the ad. They have no responsibility in looking behind the ad to see if it's been substantiated, that sort of thing. They're just a publisher. But if they have a relationship with the agency or the advertiser or both, which puts them in a position of having to know, that maybe the testimonial or whatever was paid for, but there's no disclosure, then they might be liable. But that's a separate situation from just being a publisher.
Yeah, well, he kind of shortened it down. So if he sells ads on his website to other people, is he responsible for the ad?
If that's all you're doing and you're not partnering with them or anything, and you're just selling space, you're just like the newspaper. You're a publisher. You're a digital publisher, and you're just selling ad space and or billboard space, whatever you want to call it, and you don't have any obligations to check into substantiation or anything. That's the advertiser's responsibility, and if there's an agency, the agency's as well.
Okay. All right, that's it.
That's it. Yeah. All right, guys. This was an interesting hangout because it actually fits some of our members, but not others. We hope that, and we're not going to spend a lot of time in future hangouts on agency stuff, but every now and then we will. So we appreciate your time and attention. And good night, everyone.
I saw a question, Dan. I just saw it said, should agencies run ads on their own Facebook pages with the exception that the agency sells the ads to other small businesses? I mean, you want to run just like a regular, I'll answer about it, because you don't want to run your ads on your customers' ads through your account. I mean, that doesn't make, especially if you're using Facebook or anything like that. If you're an agency, you do it the proper way and run it through the customer's Facebook page or the customer's AdWord account or whatever. That's the way you want to do it. You don't want to do it through yours. All right, I'll get the message fixed. I'll get with the programmer and get the error fixed and just email everybody that the page has been fixed or whatever. So those who want it can get a hold of it.
For those of you who do buy the book, and there are several of you, we appreciate that. You're going to be on a list for agency stuff, right?
Yeah.
Which means that sometime in the future, you're going to get an invitation to our agency webinar. So there's this, you can attend or not. It's your choice. But there's going to be more information about what is in this book. So the webinar will sort of track the book. And if you're interested, be sure to sign up for that.
Yep.
All right.
Okay.
That's it. Good night,
Thank you, everybody. Good night.